All right, well, good morning, everyone. A little bit of an eventful morning here, that's for sure. I don't know how many of you all are having internet issues, but our office is out of internet, and from what I understand, it's a bit of a widespread issue, I think, with Comcast maybe. So anyway, we're glad that you all are here. We have beautiful fall weather this morning. That's a good thing. So definitely thanks for taking some time out of your morning. We're glad that we could have you all here in this call. We had good response to this webinar, which doesn't surprise us because I know this is a very important issue that is on most of your minds. So we figured there would be a lot of interest in this. First of all, for those that don't know me, I'm Trent Hess with the BCF Group. We are an insurance broker and risk management firm here in Lancaster. And we're thrilled to partner with Jeff Worley and Gibbel, Kraybill, and Hess to jointly educate our clients here about this really consequential mandate that has pretty significant ramifications for all of your organizations. I know I don't need to tell you that. I'm sure you've probably all spent a lot of time these last few days researching and discussing and trying to learn about this issue and come up with some plans. So we're glad to help you with that here. Now, just from the time we set this webinar up last Thursday until today, things have changed a little bit. So as you probably know, over the weekend, the Fifth Circuit Court of Appeals has filed a stay on this mandate pending an expedited judicial review. So what does this mean? Where does that leave you as an employer? In a second here, I'm going to turn this over to Jeff, and he's going to start out talking about that just for a little bit at least, what the legal process looks like here with the courts, what it means, how it might play out. But then he's going to go ahead and discuss what's in this OSHA order, because frankly, none of us know what's going to happen in the court process and how that's going to end up. So we have to continue on with preparing for this really and educating ourselves about it. So that's what we're going to do. We are going to have a time for Q&A. So if you have questions, feel free to type it into the Q&A section here. We'll get to all the questions that we can. Can't guarantee we'll get to them all, but we'll do our best here. This is going to be a little bit more informal than maybe we originally planned just because of the changing situation, but that's okay. Our goal here is just to help educate you as much as possible so that you can plan and make good decisions for your company. So with that, Jeff, I'll turn it over to you.
Thanks, Trent. Thanks for everyone for being here this morning. We've got a pretty big issue to tackle, and we're gonna do this as we move forward. I do not have a PowerPoint today. We are going to be developing some materials over the next couple weeks, so continue to check back in with us. I do also think, if needed, we will be doing a subsequent webinar on this to provide you with a little bit more detail. Some of these issues are going to continue to get fleshed out a bit. Let me start out by making my malpractice carrier happy and just say that this presentation is for informational purposes only. Please contact your attorney, preferably me, to address specific legal needs. By now, you've all heard about the vaccine mandate and the testing requirement for employers with over 100 employees. And as Trent mentioned, the Fifth Circuit has issued a stay of the ETS, the Emergency Temporary Standard, which OSHA issued. Starting off with the appeal and what this means for you, as the name implies, the ETS is issued as an emergency standard that is temporary. And what this means is it bypassed OSHA's normal comment period that is typical for federal regulations. For the ETS to stand, OSHA must be able to show that the regulations, that the standard is in place to prevent a grave danger to employees' health and safety. Now, there are a number of bases for that appeal. Specifically, does COVID itself present a grave danger to employees? And the vaccination requirements, the testing requirements, are they within the scope of OSHA's authority? Do the regulations impede on business owners' constitutional rights? Do the regulations impede on employees' constitutional rights? And there are a number of factors in here that range from possibly government takings to First Amendment issues, a lot of things to ferret out. The Fifth Circuit, when it issued the stay, said that the petitions give cause to believe that there are grave statutory and constitutional issues with the ETS. Now, you'll notice something that the court did there. OSHA standard, which invokes, that it invokes for its jurisdiction, says that there is a grave danger to employees' safety. Now, the circuit court turned around and said, we see that there is a grave danger to the constitutional issues here, grave statutory and constitutional issues. I think that the circuit there is signaling that they see that there's problems with this ETS. But what was going to happen was yesterday, government submitted briefs. Today, the petitioners were to submit briefs, and the Fifth Circuit would move ahead with a hearing on this. However, this litigation is now pending in 5 circuits. So there are, I think, currently 12 lawsuits pending. And this is now going to be decided by a multi-district litigation panel, which is an assembly of federal judges who handle this type of federal litigation. The circuit where the matter will be heard will be determined on November 16th by lottery. So essentially, they're going to draw from a lottery which circuit is going to hear this matter. And they're going to consolidate all of the cases together, and they're going to make a decision from there. So if it's in the Fifth Circuit, my guess is we may see this get overturned. If it's in a different circuit, it may stand. And that also leaves open the possibility that this will go to the Supreme Court. And we have no idea what the Supreme Court's going to do. So my personal legal opinion doesn't matter. You need to prepare as though this is going to go into effect as of December 5th. I do not see that OSHA is going to have a lot of sympathy for employers who say, we were not ready because Jeff Worley had an opinion about the ETS. There are a number of things you're going to need to line up, and you cannot start doing so December 4th. I do believe that the courts are going to be moving this along as quickly as possible. But as I said, now this is going to go to the panel, and that's not going to be decided who's even going to hear this until November 16th. Panel, hearing, then possibly to the Supreme Court, additional hearing, decision. So we could be looking at butting up against that December 5th deadline. And I am not confident that you're going to see OSHA granting a lot of sympathy to businesses who said, we just kind of sat on the sideline and waited to see what the courts were going to do. Biden administration has been clear that they want to see employers start to comply with this ETS. And so I caution everybody here not to wait on this. That's not to say that, we get overly excited here either. I do think that there is a possibility that this will not go into effect, but I do think that ultimately you need to prepare as though it will. I should also mention, as we're moving along here, you got questions, please raise them as we go along. It's going to be a lot more interesting to have you guys jumping in with some questions to keep this a little bit more engaging than to have me just up here yammering on for the next hour. So please, if you have questions or comments, feel free to raise those as we move forward. So let's start out with the ETS and who does this apply to? It applies to employers who employ more than 100 employees. And how do we count to 100? 1, 2, 3, 4. Part-time counts as 1, full-time counts as 1. You add all the employees up together, regardless of the location. So if you're at a location here in Pennsylvania that has 50, and you have 50 in Maryland, you got 100. You're under the you're covered. If you have 99 remote workers, and there's an exception for remote workers that we'll get into, and you got 5 who are not remote, who work together, you're over 100, you count, even though it would only be those 5 who would be subject to the requirements of the ETS. So really, any way you look at it, if you have 100 or more employees, you are going to be covered. If you had more than 100 employees as of November 5th, when the ETS was issued, that was last Friday, you are covered. And it does not matter if you lay off employees to get below 99. Once you are covered, you are going to be covered for the duration of the ETS. And the duration of the ETS is 6 months. However, if you had 99 on November 5th and you later hire an employee, you are now covered and you cannot get out of it. So you can't get out of it, but you can get covered. December 6th is going to be the first date that you need to be aware of. And that is a date where there is a requirement for you to have in place a policy. And this policy is primarily for your employees. And this is going to be explaining to your employees and apprising them of their rights and the requirements of the ETS. This needs to be disseminated to employees on or before December 6th. And there's specific requirements for this policy. First and foremost is going to be, what does the ETS require? It's going to talk about the vaccination and the testing. It's going to provide that there is vaccines and that they are effective in preventing COVID. So there is going to be a pro-vaccine message that employers are going to have to disseminate to employees. How you as the employer are collecting vaccine status, a notice to employees that they are entitled to paid leave to get the vaccine and paid leave to recover from side effects from the vaccine. What happens in the event of a positive test? The notice is going to provide that there's not going to be any retaliation for complaining about an illness. So bringing, a possible COVID illness to your employer's attention. There'll be no retaliation for that. And there'll be no retaliation for reporting an employer's violation of the ETS. Also, it's going to notify employees that they may be subject to criminal penalties if they submit false documentation. It's going to provide unvaccinated employees must wear a mask. And for employees who do not abide by the ETS requirement, that there will in fact be disciplinary actions by the employer. So this essentially lays out what the employees should expect with the ETS. And as I said, there's a lot that goes into this notice. We're going to be working to develop a notice and can work with you to develop a notice to provide to your employees. And this is going to be pretty much of a uniform notice that just complies with the requirements of the ETS.
Jeff, we have a question here. Can I interject and ask that of you?
Please.
So this actually goes back to the 100 employee count. So the question is the 100 employee count on a rolling basis for companies with high turnover? Do you need to have 100 employees at any one specific point in time to be covered?
If you have 100 employees at any time, you are now in coverage. And once you are in coverage, you cannot get out of coverage. So if you have 100 employees and you lay off 50 of them, you are still going to be a covered entity for the duration of the ETS. And as I said, that duration is going to be for 6 months.
Jeff, is there any stipulations for companies that have multiple entities? So if a company has 2 or 3 entities that employ their employees, and one might be 50 and one might be 60, do we know what that's going to mean?
So you're going to really need to look at whether or not you're going to be considered a joint employer for purposes of the FLSA, the Fair Labor Standards Act, and that's going to really be on a case-by-case basis. There are going to be some situations where you as an employer can show that we have separate functions perhaps separate ownership, or various things that could factor in to showing that these are completely separate entities. If you have two entities who are essentially working in tandem with each other, same ownership, perhaps same HR functions, same payroll, etc., likely they're going to be covered. For those, if you have that situation where you have multiple entities, subsidiaries, you need to talk with your counsel about that to determine whether or not you are going to be a covered entity.
Thanks.
So let's move on then so we go to December 6th. We have that notice period. The next step is going to be January 4th. And that's when the testing requirement kicks in for all unvaccinated employees. And let me pause here to say, a lot of people have talked about this as a vaccine mandate. And essentially it is, but there's an out for employers. And it says, if you choose not to mandate the vaccine, you can allow employees to test on a weekly basis. The mandate itself, goes into effect as of January 4th as well. So employees need to be vaccinated if they're not vaccinated, they need to start testing. Employers have that option. So you as an employer can say, we are going to mandate the vaccine, just as you could have before this came out. That's completely within the employer's prerogative to make that determination. With the testing requirement, this is now mandated that you are going to, if there's not a vaccine requirement, then there's going to be a testing requirement, and that's every 7 days an employee must test. What do you need to do first is you need to establish who's vaccinated. And you're going to do that by looking at what is the sufficient proof of vaccination. And that could be a record of immunization from a healthcare provider or a pharmacy, a copy of the COVID-19 vaccine record card, a copy of medical records documenting the vaccination, a copy of immunization records. If that is not available for whatever reason, if the employee has lost that, then the employee must demonstrate that they've taken appropriate steps to look for that, and then they can sign a attestation that provides that they have in fact been vaccinated. That's a signed attestation that provides that the employee has been vaccinated, and that is signed under threat of criminal prosecution if the employee is not being truthful. If an employee does not provide proof of vaccine status, then that employee is going to be deemed to be not vaccinated for purposes of the ETS. If you as the employer are asking your employee, are you vaccinated? And that employee is refusing to provide you with a yes or no answer, that's my business, I'm not going to talk about it. You can accept that as that, and you then treat them as unvaccinated. As an employer, though, you are giving somebody a directive, and so if they're refusing to comply with that directive, you can view that as insubordination and take disciplinary action as well. This is going to be a bumpy road for everybody, and it would be really nice if our employees are cooperating with us through this process. But again, you do not want to probably create additional headaches for yourself either. And so that is what you're to do, though, if an employee is refusing to provide their vaccination status. If you are getting from employees that they are not vaccinated, an employer can encourage employees to get vaccinated. And so you could say, look, we have the testing option available. We would encourage you to get vaccinated, and here's the reasons why. That is lawful to do, should you choose to do so. But you should not ask your employees why they are not vaccinated, because doing so gets into questions of medical conditions. It gets into questions of religious beliefs and things that generally you as the employer should not be inquiring about at this stage. Later, that employee may be requesting a medical or religious accommodation if you are in fact mandating the vaccine. And at that point, then you can have that discussion. But until there's a mandate and until that employee is requesting an accommodation, saying, I want to be exempt because of my religious beliefs or because of a medical condition, you should not be asking the employee, why are you choosing not to get vaccinated? The ETS, well, let me back up for a second here. One of the things also is, as you are checking into who's vaccinated, who's not vaccinated, you need to be creating a roster of who's vaccinated, who's not vaccinated. You need to have a record, partly for your own records, so you know who is and who's not, who's going to be subjected to the testing requirements. Also, because OSHA, if they come in and do an inspection, probably one of the first things they're going to ask for is your roster of who's vaccinated, who's not, so they can begin to understand what the framework is in the workplace. And this does, I understand that this creates a lot of anxiety for a lot of you. The idea of OSHA coming into your workplace for an inspection and asking to see rosters of who's vaccinated, who's not vaccinated. This is simply what the ETS provides for at this time. Again, we may see changes to this. We may see that this goes into partial effect and not full effect. But as of now, this is simply what the ETS provides for. For those employees who are going to be vaccinated, the ETS provides that the employer must provide at least 4 hours of paid time off for that employee to get vaccinated if they are getting vaccinated during normal work hours. If they're getting, if you run a Monday through Friday work week and the employee is getting vaccinated on a Saturday, they don't get the PTO. But if you run a Monday through Friday work week and they're getting vaccinated on Wednesday at noon, they get the 4 hours of PTO to go get vaccinated. And then the employer is also required to provide 2 days of paid time off to recover from any side effects. My understanding at this point is that the employee would be required to use existing PTO or sick time. But if they've used up all their PTO and they don't have any left, the employer will be required to provide that paid time. Once the employee is vaccinated, there's really no additional requirements of the employer as to that employee. They're vaccinated, you have a record of them being vaccinated. That's it. They go about their business. It really becomes, the real issue here is going to be testing your employees who are not vaccinated. And that test must be done once every 7 days. And as I said, this is an option. You can choose to mandate the vaccine if you wish to do so.
Jeff, can I back up here? We had a couple questions here about the religious exemption, which you mentioned. So can you talk to us a little about the religious exemption? Are employers required to grant religious exemptions? Is there a standard form for employees to fill out? And how do they decide what gets granted or doesn't? Can you kind of just talk about the whole religious exemption process a little bit?
I'm going to do that in a little bit, if that's all right.
No, that's fine.
All right, testing. So the testing requirements, if you're doing a test, if the employee's now testing, you're going to need to maintain records of that. And again, that's going to be considered a medical record. And medical records are confidential and need to be treated as such. So you're again, treating those as confidential medical records that are kept in discrete files that are password protected. They're not being disseminated to anyone else. They may, as needed, communication with HR or supervisor, but other than that, they are strictly confidential. You can only use FDA approved tests. There's been a lot of questions about whether or not an employee can use a home test. And they can, as long as it's an FDA approved test. And I believe there's only one home test that is FDA approved. However, the employee cannot self-administer and self-read the test unless that employee is observed by a medical professional or by the employer. And so one of the ways that, we're looking at this is, can you have employees bring a self-test to work, administer it in front of the employer, and read it in front of the employer and provide the results to the employer there? That appears to be okay per the ETS. And that's going to make everybody's life a little bit simpler. And I say just a little bit. Note that employers are not required to pay for the test. So employees are required to pay for the costs of the test. And so those home tests, I think they run $25 or so up for 2 tests. So, that's the employee's cost. There's nothing preventing an employer from providing those if the employer would wish to do so. But the employee under the ETS is it's their obligation to pay for the test. However, what's not entirely clear is who pays for the time to take the test. Per the DOL, the Department of Labor, an employee who spends time taking a test, such as a physical or a drug screen, that's going to be paid time. We have not seen guidance from the Department of Labor yet as to whether or not the time spent taking these tests is going to be considered work time. Now, again, if you're doing a home test in the office, we're looking at a kind of a de minimis amount of time spent taking that test. However, if you're having employees run out to their pharmacy, to the doctor's office to get a test, that could be an hour of time, and who's paying for that? And currently, it looks like the employer may be required to do so. And until we get guidance from the DOL, my recommendation would be that you do so, because you don't want to have a FLSA claim on top of this ETS business. What about folks who are trying to get a test and can't get one? And we're seeing that with the supply chain. My daughter the other week was sick, and she's in the high school marching band, and she was insisting, I need to get a test because I can't risk infecting the entire marching band and having everybody have to quarantine if I have COVID. So I went out looking for one, and I found one, but there was about 2 left on the shelf. And I've heard other people, anecdotally speak to that. So if you're not able to find a test, if your employees are not able to find a test, document that. And I would make sure that's in writing so that when OSHA comes, you can say, we did everything we could do here, and you as the employer, I'd recommend, calling around, checking to see is, with the CVS or whomever it may be, if you can acquire tests on behalf of the employees, just so you can present to OSHA in the event of an inspection. We did everything we could do. Employees who have tested positive for COVID with 90 days prior, if you have an employee who's tested positive within 90 days, they do not need to comply with the testing requirements for that 90-day period. Employees who opt for testing are going to be required to wear a mask in the workplace, unless they are working alone in an office space or outside, not around other employees. And so we're going back to some masking requirements for those who are not vaccinated. Trent, you had asked previously about the accommodations. So let's talk about those, unless there's questions about the testing requirements at this point. Trent, I think you're muted.
Go ahead and talk about the religious exemption. I don't see any specific testing questions.
Okay.
We'll look through them here.
So the EEOC, Equal Employment Opportunity Commission, has provided guidance on accommodations for medical per the Americans with Disability Act, and for religious per the requirements of Title VII of the Civil Rights Act. Your medical accommodations, would be that somebody's coming to you and saying, look, I have an allergy. I'm pregnant perhaps, and my doctor's advising me not to have the vaccine at this point in time. Whatever the medical condition is, it's preventing me from receiving the vaccine. In those cases, you're going to the employee, you're providing them with a note, a form, sorry. You're providing with a form that, they take to their doctor fills out and says that Joe cannot receive the vaccine. I'm certifying that he has a disability that prevents him from receiving the vaccine. And, you're generally taking that at face value, unless you have some reason to believe that this employee is not being honest with you for whatever reason. But in most cases, the medical accommodation is going to be very straightforward. The religious accommodation is significantly more nuanced. And essentially what that provides for is, does the employee hold a sincerely held religious belief that taking the vaccine would conflict with that sincerely held religious belief? Well, that's a pretty subjective standard here as to who that may apply to. We do know from the EEOC's guidance that does not simply apply to mainline Protestant denominations. It does not simply apply to, the overarching teachings of the Catholic Church or any other major religion. This may apply to sects, smaller religions, and even could go to just simply an individual's personal religious beliefs that are not necessarily part of a larger religion. The question is, does the employee hold a sincerely held belief, religious belief, that is? So note here that this is not about ideology. This is not about philosophy. The EEOC and Title VII, it does not provide for an accommodation because you're philosophically opposed to vaccines. It does not, provide a cutout because you have an ideology that says, I do not believe, that the government should be mandating these. What the carve out is simply as to a sincerely held religious belief. And again, we could get into what is a religion, what is a belief. Again, these are all subjective things. The EEOC said, look, you're not really supposed to dig too far into what an employee's religious beliefs are. And, again, it's a personal belief. What I would say is, you're looking at, has an employee recently engaged in conduct that conflicts with their asserted religious belief? Did they get the flu shot last year, perhaps? We have employees who object to piercing of the skin. And they, and I heard of one anecdotally recently where an employee said, I object to my skin being pierced pursuant to, I think it was a certain biblical text. They had a nose ring, they had earrings, and they had a tattoo. Kind of hard to, hold up on that when that's the case. But again, you as the employer, do not have to dig into an employee's sincerely held religious beliefs. And so, and also note, this is really as to the vaccine itself. If you're mandating the vaccine, you're going to be more concerned about this religious accommodation. There may be religious objections to getting tested as well. I think that those would be less likely to be viable. And there's be a question of whether or not, you go to the doctor and get, your blood levels checked and things of that nature. going to be kind of hard to hold up that you're now objecting to getting tested for the COVID. But again, you're going to be looking at those on a case-by-case basis. So if somebody comes to you and says, I have a religious objection to being tested, you're not going to dismiss that out of hand for sure. You're going to look at that and begin to determine whether this is a sincerely held religious belief, and looking to what those accommodations may be that you can provide to somebody who is saying, I cannot be tested. And the same goes for wearing a mask in the workplace. We know that there are medical conditions that prevent people from wearing a mask. And, so again, if somebody's coming to you and saying, I need a medical accommodation because I can't wear a mask in the workplace, you are sending them back to their doctor and having their doctor provide a note that says that they cannot wear a mask. There is a form, and I have, a form I worked with for this particular purpose. This will probably be part of that general policy that I discussed at the beginning of the presentation here. We're going to have a form that provides, if you are requesting a medical accommodation, state the following, and you take this to your doctor and return it. If you're requiring a religious accommodation, what we're going to ask for is provide us with the belief, the sincerely held religious belief that conflicts with, getting the vaccine, or for that, in that case, getting tested. Provide us with, any additional documentation, any texts, things of that nature, which support your position, knowing that you may be required to engage in further discussions with the employer. The employee and the employee must engage in the interactive process through this, and to ascertain whether or not this is a sincerely held religious belief. And again, as I mentioned, you don't want to dig too deep into that, but you are looking at this, and OSHA is requiring that you don't simply take everybody simply that they say, hey, I've got a religious objection to this. Okay, fine. No, it's not quite that easy. You're going to need to go through the steps, because you're going to need to be able to demonstrate to OSHA why, X amount of your employees are not wearing face coverings, or why they're not complying with the testing requirements. Again, if you're requiring the vaccine, the accommodation is generally going to be you get tested. So, that's what we're looking at here. Trent, were there other specific questions as to accommodations that I didn't touch on?
I think you've reached them, and that last one was one of them, as in, if you grant a religious exemption from the vaccine, that employee would still be required to get tested and wear a mask, correct? The religious exemption from the vaccine is simply from the vaccine.
Correct.
Aspect.
Now, there could be a request for an accommodation to get tested.
Right.
But again, I see that as not quite as viable. I mean, if the testing is not as invasive, there's but we may see folks who are raising that as an objection. But again, keeping in mind, this is not, I have a philosophical objection to the government and requiring me to get tested. I have an ideological objection to this. Those do not fall under, religion as defined by the EEOC, and they are not entitled to the accommodation that Title VII affords folks based on their religion.
Okay.
The reporting requirements, as some of you may know, OSHA has reporting requirements that had death or hospitalization. There are no end dates for this in the case of COVID at this point. And so if it is a work-related hospitalization or death resulting from COVID, you must report that to OSHA. And I believe the death is within 8 hours and hospitalization is within 24 hours. And so if this is a work-related COVID case, so what does that mean? How do we determine if it is a work-related case? There's no hard and fast answer to that, because we know that people are getting COVID outside, at the movie theater, at the restaurant, at church, at wherever they may be. And so how do we determine if it is work-related? Generally speaking, what I would say is if you're looking at a situation and it is the first case of COVID in that particular working group, so that division or those folks who are working together, you're looking at the first case, probably you're not going to be able to necessarily attribute that to the workplace. However, if we all of a sudden see 2, 3, 4 cases pop up in that working group, in the office, wherever it may be, then we are going to be looking at this as a work-related case. And then you are going to have the reporting requirements in the event of a hospitalization or a death. As I mentioned before, this is a temporary regulation, and it'll be in effect for 6 months, after which we're not sure what will happen, but it will need to go through the regular comment period and go through the process of approving the regulation as any other regulation will be done. As I said, this is an emergency temporary standard. Why should you as an employer comply with this? And the hard answer here is there are significant penalties. There's over $13,000 fines for every violation. And how OSHA is going to view that violation, how are they going to view an occurrence, is going to be somewhat discretionary as to OSHA. And so if they come into your workplace for an inspection and they see that there are 20 employees who are in the testing pool who are not wearing a mask, is that one violation or is that 20? And that may depend on what the OSHA inspector had for breakfast that morning. It's going to be somewhat subjective. And willful and egregious violations are going to be in the 6 figures. We're looking at, I think it's $130-something thousand for willful and egregious violations. So just so we hear that again, I mean, 6 figures, hundreds of thousands of dollars in fines if you are willfully violating the ETS. So if the inspector comes in and you say, "What are you doing here? You don't have authority. I don't believe in your authority. Get out of here." You're going to be looking at some really significant penalties here. We do know that OSHA does not have a lot of field officers, so we're not expecting a lot of random inspections. And we're not expecting that OSHA is going to come knocking on people's door come January 5th either. The way we're probably going to see this happen is either through reporting based upon hospitalization or deaths. And so if we see a large outbreak in a workplace, that's probably going to result in an inspection. And this could also be generated by employee complaints. And it's going to take one disgruntled employee to raise that to OSHA. And they're going to come and say, "Hey, OSHA, my employer is directly flaunting the ETS. They're not requiring masks. Nobody's getting tested, et cetera, et cetera." And that's probably going to go to the top of the line there. And OSHA is going to come out and enforce that. So that's that's the stick on this end of things. Is that's the big stick that the government's carrying with this. And that's what you need to be aware of as you're considering this. We could get into, and we're not going to, whether you think the vaccine's a good idea, bad idea, this and that. Setting all that aside, setting aside your own personal beliefs, what we do know is there are going to be fines and penalties imposed if you are not following ETS and OSHA happens to come knocking on your door. Again, I don't think that we're going to see a lot of random inspections here. but I certainly would not recommend that you roll the dice on this.
Jeff, one thing I'd add to that, the penalties that you mentioned there, obviously those are significant, but just so everybody's aware of the possibilities here, the bill that's being debated right now in Congress, the Build Back Better Act, also called the Reconciliation Act, currently has provisions in it that would dramatically increase those fines. So it would make that minimum penalty go up to $50,000, and the upper end could go up to $700,000 in that bill. So once again, that has not been passed, and I'm not looking to get political here, but it's important for people to understand that in conjunction with this OSHA ETS and that bill, it's really quite the risk exposure there would be extraordinary for businesses and organizations with this. So that's just something to keep your eye on.
And also to note too, you have a workers' comp issue if in fact you are not following the ETS and you have employees who are getting sick, and there would be a question of what workers' comp will do in that situation, and whether workers' comp would impose penalties as well for a willful violation. But questions right now?
Jeff, maybe you could speak to this a little bit. So if an employer has an employee who won't get vaccinated or won't provide their vaccination status and refuses to submit to testing and or masking, are they required to fire this employee under the OSHA ETS, or how do they handle it?
That's a great question. The ETS provides that the employee needs to be removed from the workplace. So if an employee goes for a period of 7 days, testing is every 7 days, and that employee is on day 8, they are not to be allowed in the workplace on day 8 without a test, and they would need to provide a test in order to return to the workplace. There are, as I mentioned earlier, there are exceptions to the ETS as far as who's covered, and you have employees who are working remotely, who are working exclusively remotely, not 50%, 50%. They are, at a satellite office out of their home or wherever it may be. Employees who are working alone, so maybe, drivers, other folks who are working exclusively alone, and folks who are working exclusively outside. And when we say exclusively outside, that means, with the exception of a bathroom break, they are outside. Those employees do not need to submit to the testing requirements or the vaccine requirement. So you could possibly, depending on who that employee is, send them home and have them work remotely if they're refusing to do so. If they are not, if that's not an option, the rule provides that they are not to be in the workplace. That said, that's going to be a decision for the employer to make as far as, look, we're going to lose $200,000 on a job here if I, have to, send a foreman home because he's refusing to get tested. What's the risk? What's the cost benefit here? And again, I think in those particular situations, you need to be consulting with your counsel on those, and looking to determine what you can and cannot do and what the ETS provides for.
What about employers under 100? Is there anything in this that they need to do at all? Or if you're under 100, are you totally free from this whole discussion here?
Today, you are. They have already said that they're looking to make this applicable to smaller employers as well. So, at this moment, it does not apply to anyone who is 99 and below. However, if this stands, I would expect that we may see this rolled out for smaller employers as well. And I think that's one of the arguments that they're going to be making is, that this is an arbitrary number here. You don't have employers, less than 100. Your roofers don't have to wear harnesses when they're on the roof. And so there's a little bit of, I think, one of the arguments that we're going to see played out is that this is a pretty arbitrary number. But as of now, smaller employers do not have to worry about this.
Somebody asked, it says a contractor with less than 100 employees, but who has one or more federally funded subcontracts would be subject to the ETS, correct? So can you talk a little bit about people with federal work? Is that a separate issue than this OSHA ETS, or are we talking about the same thing?
Federal contractors are subjected to a separate rule. That is a vaccine only rule. There's not a testing option with those who are federal contractors or subcontractors. Who is a federal contractor is really going to depend on whether there is a contract. So we're not necessarily looking at whether there are federal funds in play. It is going to be whether or not there is a contract in place with the federal government, and that requirement for vaccines should be spelled out in the subcontract or the subcontract, all the way down to those who are supplying goods only or products. But anyone who is actually performing work on a federal contract should be subject to a vaccine requirement, and there is no testing option with that. Should also note that CMS just came out also with regulations for Medicare, Medicaid recipients. And those are nuanced for those recipients of Medicare, Medicaid. And when I say recipients, I'm not talking about individuals, I'm talking about entities. And as to their employees and vaccine status. I'm not going to get into that today. If you have specific questions as to the CMS regulations, let's talk offline. Those are separate and distinct from the OSHA regulations.
Somebody asked here about the 100 employee count. They asked, is it based on full-time equivalents or simply people? And I understood you to say it's simply people. A part-time person is one, a seasonal worker is one, a full-time employee is one.
That's correct.
And they said, if I'm at 100 employees now, when do I need to be below 100 to avoid the ETS mandate? It's too late for that, right?
Too late.
That was last Friday, November the 5th.
Last Friday, November the 5th was the time at which the regulation went into effect. And once you're a covered entity, you remain covered for the duration of the ETS.
I'm just looking through some of these other questions here. Some we've touched on already.
Let me do this then while you're looking at the questions. Is I just want to kind of run through what employers should be doing now, because as I said, we're still looking at this playing out in the courts, and a lot of folks are as I said, you can't wait till December 4th though to start trying to implement this, and so I do have some recommendations here as to what you as an employer should be considering now, so that if this remains as we've discussed today, and all of the provisions stand, that you are ready to implement the ETS requirements. So first, determining which employees are vaccinated and which are not. And this is, as we talked about earlier, going through that process, creating that roster of who's vaccinated, who's not. You would be relying on the documentation, as I previously discussed, to demonstrate that they are vaccinated or not. This is also going to assist you in perhaps determining whether or not you're going to allow for testing. If you're looking at logistically, if you have 75% of your workforce, and again, let's just use the round number of 100, so you have 75 employees who are not tested, who are not vaccinated, logistically, that's going to be very difficult to go through the testing regimen every 7 days. But on the other end is you may have 75 employees who are going to walk if you require them to get vaccinated. So beginning to kind of think through, what are we going to do? Are we going to mandate the vaccine? Are we going to allow for testing? Get that policy in place. So as I mentioned before, that specific policy, and I said, we're able to assist with that as needed. So please feel free to reach out to us for assistance on getting that policy together. As I said, there are very specific requirements as to what goes into that policy. But once you have that policy in place, that gets you through the December 5th, when you have to have that policy in place. And then we have another month before there actually has to be action taken by you as the employer. And so, the policy itself, is not going to be very difficult to put into place. At that point, you're going to have made a decision. Are we going to allow testing? Or are we going to, just mandate the vaccine? We have the policy in place. We're now beginning to communicate with our employees. And I think that that's going to be a really important thing through this process, is communicating with your employees. You don't like it as an employer, I'm sure. Your employees, many of them, are not going to like it either, because it's additional work, it's additional logistical efforts that you're taking. And, so beginning to kind of think through that. You may also want to begin to think through, how are we going to track this? Are there tracking software platforms that we may be able to utilize? I do know of some folks who are beginning to design platforms. And if that's something you're interested in, let me know, and I can connect you with the right folks here who may have solutions for that. But essentially, looking to, is there a way that we can, have an application on everybody's cell phone in which they are reporting, that they've, gotten vaccinated, how they've gotten vaccinated, how are we going to keep track of everything? So beginning to kind of think through that as well. Determining how, you're going to respond for requests for accommodations, so just, thinking through these things. Who's remote? Are there folks that we can exempt from this? Or, if, and particularly if you're in the office setting, is it better for us just to go back to a remote working situation than having to, work through the logistics of testing and mask wearing in the workplace? So, beginning to think through those options as well. Starting to think through, how you're going to respond to employees who are refusing to be tested. And what does that look like for you as well? I think that's, where I would start. We'll get through December 5th. And at that point, I'm hoping that we'll have more direction from the courts. If, come December 5th, the ETS is struck down, okay. You put a policy in place, you've done a little bit of work, but we don't have to go through with it. But if you don't have that policy in place come December 5th, now you're running in violation of ETS, and also you're playing catch up at this point. And so, my recommendation is to start preparing, start planning. I am fairly confident that by January 4th, we will have direction as to where this is going to go. And, we'll work with you through this as needed. So I think, as this begins to play out more, we'll probably hold another webinar at some point. I'm available as needed. You can reach me on my email. I believe that's available. And if it's not, it's jworley@gkh.com. You can find me on the website, Gibbel, Kraybill, and Hess. So we're happy to talk with you through any questions that you might have. And likewise, you can reach out to Trent on some of these as well. we can connect you with the appropriate resources too. So with that, I'll leave it up to additional questions.
Yeah, Jeff, I think we'll go ahead and wrap up here just because we're at an hour and I wanted to keep this to an hour. I think we hit a lot of the main questions. If you have a question that you felt like didn't get answered or that came up, like Jeff said, reach out to either one of us and we'll try to get you the resources you need to answer your questions. And I think it is probably likely that we'll have another webinar at some point here as this unfolds and we have some more clarity or things change. But certainly either one of us will be resources to help you through this. So I appreciate everybody's time and joining us here this morning. And just thanks a lot. I hope you all have a great day and we'll stay in touch and work through this. So thanks, everyone.
Thank you.